Okay, well, why don't we get started? Good morning and welcome to the 2021 Bank Council Seminar. My name is Mike Webb and I'm the Vice President and Assistant General Counsel with Western Bankers Association. I also want to acknowledge our President and CEO, Steve Andrews, who is here with us today and welcomes you also to our event. Now I would like to introduce our chair of this year's Bank Council Seminar Organizing Committee, and she is Jill Whitby, a Vice President and Associate General Counsel with First Republic Bank. Jill?
Hi, good morning. And if it's afternoon there, good afternoon, everybody. Thank you for joining us today. I'm Jill Whitby, as Mike said. I'm in-house counsel at First Republic Bank. And I had the opportunity to chair the organizing committee for this year's Bank Council Seminar. I'm going to start off with some thank yous. I want to thank our sponsor, Aldrich and Bonifin. We appreciate your support for the association. I also want to thank the association events team and organizing committee for all their hard work and our panelists for participating today. Lastly, I just want to say welcome to everybody. We're very excited about this year's event. This is the 55th year we've put this on, and we have a great program planned for today. We've got 5 one-hour panels, a panel covering the Paycheck Protection Program, another panel covering new laws affecting real estate lenders, and we'll move on then to managing a workforce during a pandemic. And then our last 2 panels will be a regulatory roundup and managing risk in the cannabis and cannabis adjacent space. So thank you again and welcome everybody. And now I'll hand it back to Mike for some logistics and housekeeping.
Great, thank you, Jill. And just a small bit of housekeeping. All sessions are eligible for California MCLE credit. The forms can be found on our speaker's handout, an MCLE forms link that you will find in the email we sent you yesterday. And we will also provide the link in the chat box below. Please note that you will have to sign the official record of attendance and mail that back to us at the address listed. We are recording today's event, and the program will be available on an on-demand basis for everyone who is registered, and that should be available by next week. We will have time for a question and answer session at the end of each presentation, and you can ask any verbal question, but we will also have the chat feature opened up where you're welcome to post questions for our speakers as well. And we please ask you that to help reduce any background noises during the call, we ask everyone to please place yourself on mute when you are not speaking. And now let's get to our first panel titled Patience and Persistence While Under Pressure, Dealing with Paycheck Protection Program. Our speakers for this event are Pamela Martinson, a partner with Sidley Austin, Michael Flynn, who is of counsel at the Buchalter Law Firm, Yale Kim, Vice President and Associate General Counsel with Citizen Business Bank, and Mike Zanpour, as Senior Vice President and Associate General Counsel with City National Bank. Pamela, I'll hand it over to you.
Thank you so much. Thank you too to the WBA for asking us to share our experiences with the Paycheck Protection Program. It's certainly been a long and interesting year and a half at this point. We want to focus today on the roles of lender counsel, those both inside the bank and at the firms who represent those banks. I'll begin by outlining kind of where we are now, how we came to this place, and then I'll turn it to Mike Flynn to ruminate on where we go from here and some of the specific issues that we've been facing. Our 2 experts, our in-house panelists, will be chiming in as well with thoughts on specific issues that they've seen and the challenges that they've had to face in the last year. So these are all based on real experiences, and we want to use these experiences to think about how banks and their lawyers can protect themselves primarily in working with the PPP. So let's start with how did we get here and what is here? So it was just a little more than a year ago, and we found ourselves really in uncharted territory, sent home pretty abruptly to isolate amid uncertainty. We kind of watched in disbelief as restaurants, dental offices, barbershops, hotels, airlines, and more ground to really a near halt. We scrambled to make sense of the CARES Act, which was issued very quickly, and the Paycheck Protection Program. And we were expected to roll that out within a matter of days with very little guidance and even less infrastructure. It was a pressure cooker situation. requiring the patience and persistence, which we titled our program about. We had to work through implementation. So in March 2020, Congress passed the $2.2 trillion CARES Act, and coupled with additional legislation over the following months, that established programs to revive the American economy. And one such effort was the PPP, that's a Paycheck Protection Program. We'll refer to it in that way. I know some of you have an awful lot of experience, but maybe some have less. That established programs to revive the American economy. Now we have a $953 billion small business loan program. It was implemented by the Small Business Administration. It permitted eligible businesses to apply for an SBA guaranteed loan through a private lender, and the SBA paid a fee to the lender for its processing costs. Borrowers had to certify that their application materials were true and that the funds were going to be used in accordance with the requirements of the PPP. So namely that the funds were used to maintain payroll, hire back employees who may have been laid off, and cover applicable overhead. And it's a quote from the program. Now, it's helpful to keep that in mind as we talk here and as issues arise in your own practice. The PPP is a forgivable loan, helping businesses keep their workforce employed during the COVID-19 crisis. That purpose, keeping workers working, drives the policy, the rules, and the regulations. See, if I could have the next slide, let's take a look at some numbers here. These numbers are staggering. Nothing could have prepared the SBA for this. As I mentioned, the PPP is modeled on the SBA's 7A loan program. Many of you are pre-approved lenders who have worked with the 7A program. Now, the PPP was not always a perfect fit with that. And after a decidedly rocky start, that program has evolved. As of earlier this month, we had over 5,471 lenders, over 10.8 million loans approved. That is a lot of loans. At one point, there were some numbers early in the program that said that within the first 30 days, the SBA had processed more loan applications than they had processed in the entire 10 years previous. So that just gives you an idea of this was completely unexpected. Nothing could have prepared anybody to be dealing with this sort of volume. Right now, we have over $782 billion in loans outstanding. So that's huge. It's really what's happened here. So to get to these numbers, like I said, the program has evolved, and the American Banker recently cited some specific ways and gave some numbers on that as well. The average PPP loan started out from just over 200,000 at first, and frankly, there were an awful lot of very large loans up to that maximum of 10 million. But right now, the average PPP loan is only about $50,000. So it is getting, think back to the theory, what we wanted to focus on, the small businesses. 44% of loans were over $1 million in the first month of the program, and now we're down to $50,000 as our average. Emphasizing smaller loans and smaller lenders, including community development financial institutions, minority institutions, other mission-driven lenders. Indeed, there was kind of a stop of issuances by the larger institutions so that the smaller ones could have sole issuance a few months ago. And glitches are being fixed. In 2020, the issue was the inability of that old E-Trans system. Some of you are cringing as I say that. That processing system for the 7A program, it couldn't really handle the onslaught of applications under PPP. But despite this, 1.7 million loans were approved in the first 2 weeks of the program. Pretty amazing. Today, the issues are much different. The safeguards designed to protect against fraud have resulted in a lot of applications being rejected, and where there's no guidance on how to resubmit or how to get any answer. And even worse, there's been almost no way to reach an actual person at the SBA to work on questions or rejections on a specific basis. Mike Zanpor, I know you and I worked with some situations. We saw some pretty bizarre emails when the SBA seemed to be using a machine learning program to respond to emailed questions. Responding to keywords in inquiries made for some really bizarre responses. If you can pick up on that. Then I think another way in which the program has approved is that we have procedures for loan forgiveness, and they recognize that there should be differences in the sizes of the loan. So there's now different forms for small loans, streamlined forms. The pace of forgiveness is picking up. There's a 60-day period that the lender has, followed by a 90-day period for the SBA. I just throw this to my panel right now. Does anybody have any anecdotal evidence of how long the forgiveness process is really taking? Yale or Mike Z?
Yeah, certainly for the I'm sorry, Mike, but yeah, for the 2 million and over, I mean, they've blown through the 90-day period. But I would say for the 150,000 and less, I mean, it's been very quick. With the Form 3508S form, we've seen within a week forgiveness decisions on those. So I think the ones that are big dollar amounts or ones that are potentially under audit, the SBA is taking much longer than the 90-day period that's required. I don't know if that's been your experience, Mike.
Yeah.
Yeah, that's consistent with our experience as well. And in certain cases, the SBA returns relatively quickly, but certainly if it matters under review or audit, it can be a prolonged period of time. As mentioned, loans over 2 million are still under review.
Great. Let's see, Glenn, could you move us to the next slide, please? Yeah, and this in keeping with that, we can see from these numbers, there's 182,000 applications were under review. This was as of May 10th. At that point, 3.1 million loans had been forgiven already. It's a lot of loans, but there were 3.7 million applications for forgiveness that are estimated have not yet been received. So all that's still working its way through the process. Okay. Really, we've had to get this to work for our clients, our bank clients, and the banks for their clients. And the intent of the program, which is, again, to keep people working, is well understood. But the technical limitations of the systems and that rush to implementation have left the actual rules or processes giving us a result that doesn't always match that intent. Let's consider a question of the PPP1 and then now the second, the PPP2 requirements and how they differed and how they ended up with some bizarre results. If you consider an example where, let's say, ABC company is a revenue producing business and it has an affiliate, XYZ, where all the employees are housed. So for PPP1, XYZ, the one with the employees, properly applied for and received a loan based on 2.5 times its average monthly payroll. When PPP2 came about, now there's a chance, right, to get another loan, but there was the requirement that applicants had to show that they'd already received a PPP1 and that they had experienced a 25% reduction in revenue. So in our case, we have the two companies. XYZ is the one with the employees, the payroll, but the other ABC is the one with the revenue, and so had to show. So either one applying for a PPP2 loan, PPP2 would be rejected. So the fair result, one would think, would be to allow the PPP2 loan because those companies are affiliates. And you can show, well, one just applied because they had the employees. But when you can't get the phone answered or you get bizarre emails, that's nearly impossible. Now, ultimately, Mike C., maybe you can comment on this. You recall this is based on a real situation, and we did get an answer. The PPP rejected the SBA rejected the PPP2 loan, and they said the same borrower had to be under the same borrower under PPP1 and PPP2. And then later on, I think we actually did get real person and they turned that around again. So how did that situation
Yeah,
affect?
so that's an interesting point. And in the example you provided, there is a potential path where the company could apply for a PPP if they took the position that the affiliate was simply a third-party payer for payroll. The challenge is, one, we're dealing with SBA rules. Two, we're dealing with data specs that are very limited in what can be submitted. And three, we're dealing with an agency that simply cannot answer and deal with live questions. So in that example, initially, the position based on the AI response was not eligible. Then we received a live response that they were eligible. Unfortunately, the data specs did not allow the application to go through, and there's simply no mechanism at the SBA to effectively deal with those sort of issues on a timely manner. We ultimately received an additional response of non-eligibility. So it ended up being very difficult to deal with, but that's probably an anecdotal example that would characterize many of these situations that come up that are not inside the box.
Yeah, and that's really what we're spending our time dealing with. Let's go to the next slide. And I'm going to turn this over to Mike Flynn for a minute to talk about, since we're really done with the application process for the most part, we have to live with these loans and work through the forgiveness process. And Mike, how are you counseling your bank clients now? What sorts of things are coming up?
Well, Pam, before I get into that, I just wanted to amplify on a couple of things that you said. First, I want to thank WBA for inviting all of us to participate. And secondly, to talk a little bit about your comments about what a big program this turned out to be. And I was going to say, while it had a rocky start for people working the loans, banks and applicants trying to figure things out, trying to understand how to get data to SBA, trying to figure out how to interpret the rules. And the rules were reinterpreted on a fairly regular basis. There were many interim rules that were published. But the core goal of the program, which was to get money out into the economy to keep people employed, both I think is sort of a prime the pump kind of thing, but more importantly to keep payrolls and employee lists full. Businesses jumped on that quickly, and money got out very quickly. The first month or so, I think it was about 350 billion went out. Congress had to extend the program in terms of timing and had to vastly increase the funding available over several iterations. And the result was the data that Pam showed us in terms of the amounts. For anyone who's ever worked on these kind of huge government programs, this one was unbelievably successful, I think, on its own terms. And it put an awful lot of money into the economy and saved a lot of jobs. And particularly to Pam's point about how at first there were large businesses involved, a lot of the loans went to larger businesses and later smaller ones. I've personally seen, and I'm sure everyone else here has too, people you meet, your local dry cleaner, a restaurant owner, or a small client who couldn't figure out how to work the program at the beginning, or didn't even know about it or know that they could possibly be eligible. Because of the extensions of time, these people have been able to get into the queue and get their loans, which has been a great thing. And it's made the program, I think, a huge success. A big burden for the bankers that work on it. The volume's incredible, but that's what we inside and outside banking lawyers are here for. So with all that in mind, let me say a few things about forgiveness. We are really in forgiveness mode with Monday being a holiday. It's likely tomorrow really is the last day that anyone's going to get an approval for a loan. So we are looking at the forgiveness world. The issues on original approvals will likely come up again as SBA, if and when SBA reviews individual loans, and we know they're reviewing loans of over $2 million, they may pick others as well. So although we're not going to focus today on originations and the issues coming out of origination and approval, they will cycle back for some lenders as the SBA looks at loans and wants to understand what happened on the approval or why the lender approved the loan. Although we should keep in mind that for approvals as well as forgiveness, lenders, to a very large degree, this was set up to protect lenders, to make them anxious to participate in the program and give them protections in that if they could rely on data and certifications provided by the borrowers, so that one is hopeful that the exposure for lenders on the origination side, on the loan application side, we hope it's going to be somewhat limited. Time will probably tell as the federal oversight groups of various committees and others look at it. And we'll probably end up having another panel next year about the litigation involved in this program. But for now, those issues are kind of in abeyance, and I think we're really looking at what are forgiveness issues. The first thing I want to say about forgiveness is it is largely, we'll go through some of the things a lender has to do, but this is largely a function of the borrower. Borrowers have to fill out the applications. Borrowers have to submit the applications and the related data, do their own calculations, and then move it forward. And if they don't like the result they get from the lender or from the SBA, they have appeal processes. It's up to the borrower to do those things. And so that leads us to an important point about the role of all of us who are attending this webinar. There's a lot of pressure on banks from the business side. Their clients want help, and we've all seen this in this program, where the clients really want help understanding what they should be doing and what they shouldn't be doing. And all of us have either counseled our employer or our clients on the extent to which they should be helping them. I think the key thing to remember is before we get into the specifics, is generally this is the borrower's job. The lender can sort of say to the borrower, go look at this, go look at that, but really can't tell the borrower, it's okay to say this, it's okay to say that, it's okay to assume your numbers mean X, Y, and Z, for a couple of reasons. One, that's really not the lender's function. You don't want a borrower coming back and saying you misled them into a bad application or a bad result. And two, you don't want to necessarily dig below the level of information that the forgiveness process requires the lender to have. You don't necessarily want to take on the burden of looking at all sorts of backup documentation or information that could then cause you to have to do much more investigation or potentially deny or partially deny the application for forgiveness, which would put you in a very uncomfortable position with many clients. So I think it's important to keep that in mind. And I think it's all in that regard, it's also important to make your customers, the borrowers, understand they need to have people on their side who understand this. And I've seen recently, I'm sure Pam has too, an uptick in the number of smaller businesses coming to us looking for advice on forgiveness because their banks would not or could not answer all their questions. And I think the bank's position was appropriate, so that these borrowers have to find competent counsel or other advisors, accountants, someone who understands the programs. It's really important. And I would recommend that anyone working on behalf of a lender in this situation advise the clients to do that for two reasons. One, it protects the clients. I guess three reasons. One, it protects the clients. Two, it makes an application approval more likely. And three, it ultimately protects the lender by having the client do things the right way. So with that in mind, with those sort of caveats and warnings in mind,
Hey, Mike, can I interrupt you a minute and ask about, as long as the enforcement, you raise a really good point about that the lender shouldn't go sticking their nose where it doesn't belong, essentially.
Yeah.
Don't go looking for trouble.
Right.
But I couldn't help, you and I talked about this a while back, and then a week or so ago, we saw the DOJ investigation of Cabbage on the fintech side. I don't know if you're planning to mention that, stop me if you were, but that I've been reading through that, and they are investigating a lot of fintech companies, the most prominent being Cabbage, to determine if they miscalculated loan amounts for the loans in the application. And the problem is that they seem to say that fintech, because they used high-speed software and automated lending platforms to process and approve those loans, there were few manual checks, and there may have been some software glitches, and that automated system exacerbated loan errors by replicating miscalculations across thousands of loans. So they're examining those errors. So when I see that, I have to ask myself, what they're saying is, you made errors by using automated systems. You didn't do manual checks. Are we supposed to infer that we should be doing manual checks? I mean, isn't that exactly what we're talking about? Is that we're supposed to be able to rely on the certifications of our borrower?
Well, I'm going to go into that in terms of the three different forms of forgiveness you can use.
Fabulous.
And as a beginning point, let me say that as with everything involving SBA and any government regulation, the answer is maybe, maybe not. It always goes this way. Let me start by saying, though, first, for anyone who's not really familiar with this and wants to understand more about the forgiveness process and rules, a few months ago, following the introduction of the second draw loans, SBA put out another interim rule incorporating and restating all of the forgiveness process rules and requirements for both first and second draw loans, which was great because they haven't been very good about, they've had a tendency to layer a partial new interim final rule on top of other interim final rules. And you have to go back and read them all in sequence starting, last March or April. And their FAQs are not always fully on point and don't always necessarily seem to exactly align with a rule or leave something out that the rule had in. So this is an extraordinarily helpful tool. It walks through everything in a very logical manner and explains to you what the borrower has to do, what the lender has to do, when it has to be done. And it essentially breaks it up into a few different conceptual ways of thinking about it. One is, what does the borrower have to do an application? Second is, what does the lender have to review? Third is, if the lender doesn't deny the loan, what happens? Fourth is, if the lender denies the loan partially or in full, what can the borrower do about getting a lender or SBA review? And then finally, if either as a result of such a request from the borrower or because the SBA on its own initiative reviewed loans, and it's, as the panel has discussed now, it's reviewing loans over $2 million, so this will come up. The borrower can, if the SBA issues a final decision denying a loan, the borrower may appeal to the SBA administrative process to an administrative judge to try to get that changed. I haven't worked on any of those yet, so I don't know how readily those judges are listening to borrowers. But if the borrower made a mistake in those kind of hearings, in my experience with administrative judges, they are very careful to follow the rules, and regardless of whether it's an outcome that looks in a certain sense, good or bad, if you haven't followed the process, you won't get the relief you're seeking. But with that in mind, let's talk first about the borrower. The borrower, when the borrower submits an application, the lender has 60 days from receipt to submit its decision to SBA, and if it's approved, and then that SBA has 90 days to respond to that. And if SBA accepts the lender's decision, either after a review or chooses not to review itself, the guarantee money is sent to the lender, and the lender advises the borrower it doesn't have to repay the loan. If the lender denies the loan, it advises SBA, and if SBA doesn't review, the lender will advise the borrower of the denial. And when the borrower, that will normally under loan documents, depending upon the timing of your loan terms, that could trigger the end of the deferral period and require the borrower to start making payments. I should note that if the borrower does appeal an SBA final denial, that doesn't stay the end of the deferral period. So there's no sort of grandfathering in the deferral period. This means that borrowers should get their applications in quickly, respond quickly, and to the extent they can, push their lenders to move their processes absolutely as fast as possible. But let's talk about what actually must happen. There are three different forms a borrower should use. There's the standard SBA form 3508, which is a SBA loan forgiveness form that's being used for this program. It requires the borrower to fill out a lot of information, do some calculations to meet the requirements for forgiveness for various categories such as payroll, rent, mortgage interest, that sort of thing. The payroll one is complicated because it involves questions about, did you have certain levels of reductions of employees or certain reductions in salaries of employees and other multipliers that factor in. So it can be a fairly complicated worksheet for anyone who's looked at it. That's the basic form. If the borrower uses that form, what the lender has to do is first confirm receipt of the borrower certifications contained in the form. And there are a number of certifications the borrower makes that its calculations are accurate, that it's entitled to the forgiveness, the same kind of certifications you sort of saw in the initial application forms. Then the lender has to confirm receipt of the documentation required. Each of the three forms I'm going to talk about and their instructions contain detailed information on what documentation the borrower must provide, and the lender is to confirm that that has been received. So that's an affirmative act the lender must engage in. And then thirdly, the lender must confirm certain of the borrower's calculations. I'm not going to go through them all. They're laid out in the interim final rule I mentioned, but they are calculations involving the dollar amount of the borrower's cash and non-cash compensation, how much they have in mortgage interest payments, rent, lease payments, things like that. And the lender doesn't have to dig below them. The lender has to look at the borrower's calculations and say, is this math on this page that they submitted to me correct? They have 2 times 6 here, but they put down 14. It should be 12. That type of thing. The lender doesn't have to dig back into the data. If the borrower submits all the documentation it's supposed to, the lender is allowed to rely on the borrower having had the proper documentation and that the documentation is accurate, provided the borrower gives the certifications required and the lender is acting what's called good faith, i.e. doesn't know or doesn't have a reasonable reason to know that there's actually a problem there. The second form is the easy form. That is for loans over $150,000 or forgiveness of $150,000 is sought. And the borrower hasn't reduced payroll or taken other steps that require more complex calculations. It's a simpler form, but again, the lender has to go through essentially the same steps: confirm receipt of the borrower's certifications, confirm receipt of the required documentation, confirm the calculations that are specified, and then move forward. Then there's a third one, which is the form 3508S. That's the short form for loans of less than $150,000. These are very streamlined, and the SBA made it clear in all their comments and in their FAQs and everything else that they want to move these quickly, that they aren't saying this, but they aren't quite as concerned about the level of minute accuracy in these applications as they would be for a larger loan, because these are largely smaller businesses. But again, the lender still has to confirm receipt of the borrower certifications on the form. And if it's a second draw PPP loan, the borrower didn't provide detailed information at the application, they need to get certain information at this point. That's a special extra requirement for PPP loans. And I should say that if a lender in general, if the lender identifies errors in calculations on these forms, or a material lack of the information required as substantiation, they don't have to drill back into it in general, but they do need to look and make sure that what's required to be submitted is submitted. And they should be all right. In terms of the form 3508S, the short form, if the lender identifies errors and looks at the calculations, as long as those look all right, the lender should be all right. However, the lender, well, hold on just a second, please. The lender should be all right, again, without having to do very much digging. But that's the basic. However, I should say, if the lender, I'm sorry, I'm looking at the wrong portions of my slides. Bear with me a second. I've managed to confuse myself. If the lender does what's required and acts in good faith and has confirmed all things I just discussed, the lender gets a hold harmless, where the rules say that they will not, the SBA and federal investigators will not initiate any sort of enforcement action, and the lender won't be subject to SBA penalties in regard to the loan. So that's the fundamentals of that. But I wanted to then go on and talk about timing requirements here, and which I discussed earlier. 60 days after receipt of the loan application from the borrower, the lender has to issue its decision, and then SBA has 90 days. And then I want to talk about, well, what happens if the lender thinks it needs to deny the application in whole or in part? If the lender does that, the lender must advise the SBA, and the SBA may decide to review the loan. And if one thing the lender must do if it is denying a loan, it needs to confirm to the SBA that the information that's provided accurately reflects the lender's records for the loan. In other words, if you're filling out an application and the borrower submits documentation that is clearly contradictory to what they gave you during the application phase, you have to deal with that as a lender. You have to go back to the borrower. The rules say the lender should go back to the borrower when there are these type of discrepancies and straighten them out with the borrower. That doesn't mean you tell the borrower what to do. What I've seen lenders do is simply advise borrowers that this information seems lacking, or this looks like one of the owners is in bankruptcy. Please clarify. Then it's up to the borrower. I've advised lenders not to explain to the borrower how to go about proving that the owner is not in bankruptcy or other such requirements, but the lender does need to let the borrower know about them and give the borrower an opportunity to deal with them. If the lender goes all the way through and denies the application, it has to inform the borrower it's done so and that it's advised the SBA it's been denied. It needs to advise the borrower has the reasons for the denial, and the borrower has 30 calendar days to seek SBA review. It's important to realize here, though, the lender needs to let the borrower know that SBA review is not done directly by applying to SBA. Borrower needs to apply to the lender, and the lender then passes that on to the SBA. And if the borrower does that, the lender has some very quick responses they have to deal with. If the borrower submits a notice that wants the lender to advise the SBA the borrower wants to appeal or wants the SBA to review the lender's decision, and note here I'm talking about review, not an SBA appeal. SBA appeals only come off of SBA final decisions. This is a review of the lender's decision. The lender has to, within 5 days, notify the SBA the borrower's request for review, and must then submit documentation to the SBA within 5 days. The SBA can notify the lender that it is going to or is not going to do the review. The SBA is not obligated to do a review just because the borrower asks for it or the lender passes that information along. If the SBA declines to do a review, the lender has to notify the borrower, and that in effect becomes a denial of the loan. And then the triggers for the borrower doing an appeal to SBA come into play. I'm not going to talk about that appeal process particularly because that's a borrower-driven activity. The borrower has to do all that. What I want to talk about instead is what should the lender do if it does receive a notice from the SBA that the SBA is reviewing a loan? I suspect any bank that's doing any significant number of these loans and that started at the beginning of this program when there were a lot of larger loans made has received such notices or is going to receive such notices. And what should the lender do about it? Well, within 5 days of receipt, as indicated, the lender should transmit to SBA electronic copies of a host of documents described in the rule, and that they also have to request the borrower to provide the lender with various applicable documents that the lender then is supposed to pass on. The borrower doesn't have to submit all documentation. The documents specified in the forms for the borrowers to submit is not every single documentation piece the borrower would have. So when the borrower is seeking an appeal, it has to submit additional documentation information to the lender, which the lender passes on to the SBA. And has to do that within 5 days of receipt of any information from the borrower. So these are very quick deadlines for a lender, and I think lenders ought to pay attention to this part because this is a very sensitive area. If a borrower has been denied a loan and wants a review, and the lender isn't helping it get its allowed review, that's going to reflect very poorly on the lender with the SBA, and will look very bad, not only immediately, but look bad later on if this loan ever turns into litigation or some sort of enforcement action. There's going to be a record of the lender not having done what it's required to do, which is just going to make it a much more difficult situation. If the SBA was to make any decisions based upon incomplete information because the lender failed to pass some along, the lender might face difficulty with its client borrower, perhaps even some liability issues because it didn't follow its obligations for the borrower. So the lender needs to pay this particular area. When a borrower announces it's seeking SBA review, a lender must move very quickly.
Yeah, Mike, if I may just briefly interrupt, I'd like to add some color to some of the points you've addressed. I think first, the good faith review is very limited, but in terms of defining what the good faith review, I think that's a challenge for lenders. When this program initially rolled out, there's really a distinction between the origination review process, which focused on historical payroll, and the forgiveness review process, which focused on how funds were spent during the covered period. When the program was initially rolled out, you had typically a formula of 2.5 times payroll versus 8 weeks to spend the funds. So to the extent there was an excess loan error, it would typically be addressed due to the duration of the covered period. With the PPP Flexibility Act, the covered period was extended from 8 weeks up to 24 weeks, which created an issue to the extent that if there was an error on origination, if the client applied for a loan beyond what they were eligible for, they could then probably still spend it within the covered period. And if the forgiveness process focused fully on the covered period, given the scope of review, you may end up with a decision approving full forgiveness. So the SBA published a procedural notice on excess loan amounts, which basically says to the extent the lender identifies an error with origination related error, the lender has now an obligation to deny forgiveness to the extent that the borrower received an excess loan amount. So what this procedural notice effectively did was it incorporated the origination review process into forgiveness to the extent that the lender is placed on notice. From a practical perspective, what's happened is clients have gone through 2 rounds of PPPs. Round 1, they may have used 2019 payroll. There were certain rules available at that time. For round 2, they could still elect to use 2019 payroll, but the rules have evolved and the SBA checks have evolved as well. So there may have been a client that applied for a PPP loan, received the full amount in 2019, using 2019 payroll. Same client applies for a round 2 loan, and due to SBA validation checks, is deemed to have applied for an amount in excess of what they're eligible for. At that point, now the lender has the onus of going back during the forgiveness process when the client applies for forgiveness in round 1, not only to do a good faith review of the forgiveness application, but now there's an origination review that needs to take place as well. Another common example that comes up is with independent contractors, inclusion of independent contractors within payroll. This, to the extent those issues come up during the origination review for round 2, now the lender has to go back and appropriately flag the loan for round 1. So I think the general point of lenders don't want to dig in beyond what they need to with respect to the good faith review. It's kind of a general proposition that general rule of thumb that we all follow. But again, the challenge that lenders face is we have all this information that we received throughout the program at different phases that may potentially impact our good faith review. I also want to touch on the denial decision, because I think the denial decision is unique. The approval of forgiveness, the approved in full, approved in part, those are decisions that the lender makes that are submitted to the SBA for review and pending final SBA review. But as you mentioned with the denial, if a lender determines that the client was ineligible for the PPP loan and decides to deny in full, that's really a unilateral decision that the lender makes. As you mentioned, the lender informs the SBA and then sends a notice to the borrower, giving the borrower 30 days to seek review. And as you mentioned, to the extent the borrower seeks review, now the deferral period has stayed, and the SBA, again, now has 90 days if the SBA takes on the review, has 90 days to take that on. I think lenders and borrowers need to be prepared, as you mentioned, to act very quickly, because there are very strict procedural deadlines for lenders to meet. And to the extent that a lender fails to meet the deadline, or even borrower fails to meet a deadline, the consequences are pretty severe in terms of prejudicing any sort of rights with respect to forgiveness on the borrower side, and potentially the SBA guarantee to the extent there is a dispute and it's the result of lender error. But again, from a practical perspective, Mike, it's particularly challenging given the variance in the rules and changes throughout the program. And from our standpoint, one of the key things to look at from the good faith review perspective is what rules were in place at the time the lender handled the review. And so I think that's critical from a lender's perspective in terms of understanding what rules are in place through the review process. But I'll turn it over. I just want to touch on a few points.
Those are very good points, Mike. And I want to sort of spin off of one of them, which was you're mentioning both how you can end up in both an application review, an initial application review, and a forgiveness application review. I think there can be an issue sometimes where borrowers on their forgiveness application are submitting data that simply doesn't align with the original data they submitted for the application. And this can become pretty apparent from the forgiveness questionnaire that the SBA created that everybody has to fill out. Those discrepancies in numbers sort of jump off the page. If you're at all familiar with the data they submitted for the original application, some of the numbers of where they are now, either in terms of revenue or employment, really can stand out. And I think borrowers or lenders need to pay attention to that. Absent some reason to be suspicious, you don't have to dig into the background of all the information they gave you. You don't have to review. If they gave you payroll records from their payroll company, you don't have to dig down and see what day did this employee leave, what day did that employee leave. But if you look and they're showing when they applied for the loan that they had 1,000 employees, and on their questionnaire they're suddenly saying they've only got 300, but they don't claim any reductions, that's something you better take a look at and ask them about and to get them to explain it, because it does appear to be a serious discrepancy. You have knowledge of it. And so I was wondering, Mike, now, I don't know what your bank does, I don't put it on the spot, but what you would recommend banks consider in terms of the degree to which they look back at their own records from the loan application era of this to look at a forgiveness application. Do you think they should look at anything, or should they highball it, or how would you recommend they think about it?
Yeah, so I think that's a really good point. I think the general rule again is unless we have knowledge to the contrary, we're going to rely heavily on the client's certifications with respect to eligibility and the good faith review that transpired in the application process. The issue that comes up, and there's an interplay between our bank's obligations to report suspicious activity outside of PPP and the program rules itself. But the issue that comes up is once the bank has knowledge that there's a potential eligibility issue or a calculation that doesn't seem to pass the smell test, now there is an obligation to do a review. And so I think a prudent approach for lenders is to have a flagging system. To the extent that items come up with respect to specific borrowers, I think there should be a flag to reevaluate the origination review in order to comply with the SBA's excess loan amount guidance. But that's a challenge that lenders grapple with. Again, because the way this was initially set up, the idea was you handle the forgiveness review process completely independent from origination review.
That's a good point, Mike. And I like your idea that you have a specified process. I don't think you should be doing it ad hoc on each loan. I think the more you have it set up as a documented process with people trained under it, the better off you'll be if any problems do develop. And more importantly, the less likely problems will develop. And particularly, I think, with a focus on the larger loans. I mean, you just have to drill down that way on the larger loans. One thing I want to bring up really quickly that the group had talked about when we were planning this panel was a question of how much should the lender be involved if there are audits of the borrower, i.e. SBA reviews of the borrower? What should the lender do beyond what I described earlier of delivering information? And I think what the lender should do is stay out until the SBA asks you for information. If the borrower is being reviewed by the SBA, the lender really should not be advising the borrower on what to do, how to respond, that sort of thing. That's not your role in this case. The borrowers have their own obligations. And if it doesn't work, you don't want the borrower blaming you. So I would strongly recommend, I'm sure everyone agrees with me, that you have to be careful with your loan officers, your salespeople who are the direct contacts with all these borrowers. You have to train them. I've gotten, I'm sure Pam has too, I've gotten lots of calls from loan officers out in the field who somehow got my phone number and have gone around their in-house counsel and called me directly, hoping I would give them guidance on how to help them advise their clients. And I always tell them, well, the answer is call your in-house counsel or tell your client to read the rules, something like that. But it's something to watch out for because it's just natural that the people on the business side will be doing things like that. Pam, any thoughts on that?
Yeah, I just add that it's really important to develop a process and a specialized group to handle SBA reviews and audit-related inquiries. They really come in through two channels. One is through just your traditional platform request. And it's in that case, really what the bank is doing is acting as the intermediary, collecting information. And the bank has to be very careful not to be in a position where bank is providing any sort of advice to the client with respect to the pending review. There's also a separate channel where these matters come in, and that's typically through the Office of Inspector General. And in that instance, the bank's legal process team is typically focusing and gathering information and providing it for review. But yeah, I agree. It's critical to avoid having relationship managers who have a tendency to want to help clients. It's important to set parameters for those folks.
Yeah, I agree.
And
Go ahead, Yale.
Yeah, I was just going to say, Pam, just quickly, on the good faith review at our bank, at least from the in-house perspective, we actually created a very simple checklist, kind of like Mike's flagging idea that he came up with. So our reviewers have, in particular, the loans that are getting reviewed by the SBA, that we sort of have a checklist of the review and sort of highlights of the items that we've looked at, so that we're not just relying on the internal reviewer of the bank to basically interface with the SBA, that we have something in writing. So, maybe some of the other in-house counsel folks on our call have a similar system, a flagging system or a checklist system, but I think that's an important a review mechanism in the event that the SBA comes calling to our customers and also wants to know how you did your good faith review, because obviously if they're looking at the customer for additional review, you as the bank don't want to be looked at as having missed an obvious and material error in the forgiveness application. So I just wanted to throw that out there. And then Pam, I just wanted to give you a heads up. We've got 10 minutes, so we need to sort of move things along on the agenda here.
Right. Thanks, Yale. And I think one of the things we did want to talk about, because we're seeing a lot of activity there, and it follows on with what Mike Flynn was saying about, where do we as outside counsel get calls that are going from relationship managers who are going around their internal legal department? I would say it's in the change of ownership area in particular. That's M&A activity is strong. Everybody's seen what's been happening in the last year. We're crazy busy. And companies are distressed, and there are deals to be had out there, or they're just looking for an exit and they put it off too long. So in many cases, the entity that was acquired obtained a PPP loan, and it has not yet been forgiven. That's why that question about how long does forgiveness take that we've been bandying about is an important one. Now, the standard form SBA promissory note, which almost everybody used in these cases, it prohibits the sale of the borrower's assets or a change of control without the lender's consent. There was a whole lot of confusion over what that was last summer. And finally, in October, the SBA issued guidance on the topic. So lenders can consent to a change of what we call change of ownership, or if the borrower applies for forgiveness and places funds in escrow that are adequate to repay the loan. So that sounds pretty simple, right? But then we get back to what Mike Zampor was talking about earlier with the 8-week period or the 24-week period. 8 weeks was pretty quick. That was all fine. But now that people have 24 weeks to use the funds, they're not so eager to go ahead and apply for forgiveness right away before that period is up. The buyers of these companies are pushing hard for companies to get rid of that PPP loan. A lot of times the buyer is a private equity sponsor. They clearly, after the issues in the press of last year, have a lot of reputational concerns. So they just would like that loan gone. And there's a delay in trying to get the PPP loan dealt with. Well, you have a perhaps distressed business that really needs to get out and get going. It hurts the employees in that case if we can't make something happen quick. So, and then we've got the corner case, which we've seen in some places where the company that's being acquired is failing and actually the purchase price is less than the PPP loan amount. So now you have the question of maybe they can apply for forgiveness, but that's going to take time. The company will fail by then. And in any event, how can you put money into escrow? So that's if they don't have it, and the amount that's being purchased, the purchase price is less than that. So it's become a difficult situation in trying to figure out how to comply with that. And a lot of entities are just saying, forget it. I don't even want to deal with what seems to be the simple guidance from the SBA, but just pay the loan off. So I wanted to ask Mike and Yale, have any of you seen, what do you think the bank needs to provide consent to this type? Is it fairly automatic that, okay, fine, if they apply for forgiveness and they put the money in escrow, you don't ask any other questions about the ownership change?
Yeah, that's a good question. I think, from a procedural standpoint, we have a very narrow path to provide unilateral consent, and assuming the client can meet the requirements per the procedural notice, November 2020, I think the bank, if it's only a PPP loan on the books, then it's relatively simple. It gets a little more complex if you have legacy loans as well, because you now have to take those loans into consideration. But I think with respect to change in ownership, what's become particularly challenging for banks is, the procedural notice allowed us to go through this path. With the round 2 loans, you have borrowers re-entering the covered period, and they're unable to submit a forgiveness application to meet to allow the bank to provide unilateral consent. So the big challenge that we're dealing with in those instances, we have to go to the SBA for specific consent. That process can take, in certain cases, 2 months for the SBA to respond, and that puts borrowers in a bind. And we've had instances where borrowers just, they either pay back a forgivable loan, or in certain cases, there's strategic defaults where they just proceed, and then the bank ends up reserving rights. They go through the forgiveness process. In certain cases, the SBA actually grants forgiveness. So it's a particularly challenging area from both the bank and the borrower's perspective.
Great.
Yeah, and I was just going to quickly say that that this is the area that I think, and Mike probably faces this too, where us in-house counsel folks are getting the most interface with outside counsels, borrowers outside counsel on this issue, because they're so bewildered by the fact that they actually have to put up money to back up their loan, a PPP loan, when they're going through this change of ownership process, in addition to the consent issue. And so, I think that's one issue that I think most of us in-house counsel folks have had to deal with on a pretty regular basis. And so, I just wanted to mention that. And also, just on Mike's point on the second draw loans, it just seems absurd that the SBA is requiring, funds to be put up as a backup to a PPP loan when the PPP second draw loan funds haven't even been expended. The 8 to 24 week period is not even applied. So do they take the PPP loan funds and then turn it around and then put that back right in as effectively security for the PPP loan that they just took? So I think there's some absurdity to that. But again, these are issues for our in-house counsel folks that you will be dealing with outside counsel on, because the borrowers are so invested on this issue that they will retain outside counsel to help them.
Let me quickly address.
Mike, we've got a question from the chat room.
Yes, I want to quickly address that.
Is that the one you're going to address? Go ahead then.
So the question is, what happens when the lender finds out about change in ownership after the fact? And that's actually quite common occurrence. SB's procedural notice on change of ownership doesn't address a situation where the change of ownership has already taken place without the lender's consent. So there's really two potential paths there. One is the lender simply sends a notice of default with a reservation of rights. The typical approach is to allow the borrower to go through the forgiveness process to determine whether or not they will receive forgiveness. The other approach is to enter into a forbearance agreement with the borrower, where a forbearance escrow is set up. The bank agrees not to exercise rights or remedies during the forgiveness process. So both approaches are potentially utilized if the borrower wants peace of mind that no enforcement action will be taken. The forbearance escrow approach is probably the best approach.
Yeah, and one other thought on this is, and you say, well, because I have so many clients who ask this, why should I go ahead and comply? Why don't I just go ahead? What does it really mean to be in default under the PPP loan? And that's been a good question. At the very least, we do know that there will be a report to the credit scoring companies. So, especially on the smaller end, that's probably a significant problem with it. So you shouldn't really ignore it with it. And again, do you think that if you failed to catch this at all, Mike Yale or Mike Flynn, would the SBA have any use it as a lever to deny the guarantee?
I don't think the SBA would have a basis in that scenario, because I think if a bank consents to change in ownership in a manner contrary to the rules, then you have potential guarantee denial. But in an instance where the borrower has violated the terms of the promissory note and changed ownership without consent, then I think it's just your typical default situation, and I don't see that as impairing the guarantee.
Right. Sounds good.
Yeah,
okay.
I would agree with that. It just seems like the forgiveness process is going to be finalized anyhow, and if they've already done the change of ownership as lender, there's nothing you can do other than potentially notify the SBA of that, and it really shouldn't affect your guarantee because it's nothing that the lender did to cause that guarantee to be revoked.
I think the key thing is you should probably let the SBA know and make it clear to them how you solve this so that the SBA is not running any risk on this, that they're covered. Their guarantee is not more likely to be invoked because of this event. Otherwise, you are running a risk on the guarantee.
Yeah, Michael, I will add that that's the typical part in terms of sending the notice of default reserving rights. You immediately then notify the SBA through the portal that this occurred and that the lender has reserved rights. Typically, the SBA hasn't provided specific guidance in terms of next steps. I mean, a concern would be if the SBA takes a position, hey, you should accelerate the loan based on the default. They haven't done that. So the typical approach for lenders is just basically to reserve rights and allow the forgiveness process to play out.
I would say for companies that are not in good shape and aren't going to the lender to set up a proper escrow for these kind of transactions, they need to keep in mind that if the lender declares a default, that can be a red flag, not only to the credit union, but to the SBA to then open up the entire file, which you don't want to get into.
Yeah, I think that's what the concern is that they'll have closer scrutiny because of this. And clearly everybody would like to avoid that and so on. Great. We are coming up on our time. We're in our last minute, I know. So before we close out, I just want to see if there's, Glenn, are there any questions that we have not addressed? I know we tried to get the ones out of the chat room. But if there's anything else, let's talk about that now. Otherwise, I'll let our panelists have a final word.
We do not have any questions that have come to me through the chat box. So no more questions at this time.
Okay, great. Any other final points here in our last couple seconds? We're good. I think that it has been a fascinating year. It's certainly something that none of us ever expected. I know that I was an SBA lender over 35 years ago, and never in my wildest dreams did I think that at this point in my career, I would be circling back to SBA loans. But it's been fun. Certainly, we've enjoyed tussling out some of these situations. and look forward, as I think Mike Flynn suggested, next year we're probably going to be talking about enforcement issues and investigations. So looking forward to another year.
Great. Thank you, Pamela, Michael, Yale, and Mike. Great presentation, and we appreciate it.